partners. Thank you for joining us for this Final Friday's webinar. Today's webinar is Brady v. Maryland, Meeting Ethical Obligations Through Brady Protocols and Brady Lists. This completes our two-part series on Brady's issues. Today's presentation and guidance must be kept in its national context. Because disclosure is a duty, all prosecutors must follow their office's policies, local bar rules, state bar rules, and as applicable, the ABA rules of professionalism. This training is made possible by a grant received from the Office of Justice Programs through their Bureau of Justice Assistance. APA is very appreciative of their financial assistance and commitment to improving the administration of justice in the prosecutorial profession. At the conclusion of the webinar, you will be emailed a short electronic survey regarding this webinar. This survey helps us continue to provide quality training to you at no cost to your jurisdiction and assist in future planning for continuing legal education. We have applied for 1 hour of ethics CLE from the state of Virginia for this program and will email your certificates after the approval is obtained. Please do not leave the training early as we use the attendee reports to verify attendance for CLE purposes. Also, please contact us if you need additional documentation of attendance for your local compliance. During today's webinar, you will be able to submit questions for the speakers using the question box on the GoToWebinar toolbar located on the right side of your screen. These questions will be forwarded to the speakers and we will try to cover the issue during the live presentation. If you need additional assistance, please feel free to contact us or the presenters directly. Today's presenters are Michelle Waymeyer of the Marion County Prosecutor's Office, John Elison of Mesa City Prosecutor's Office, and Bob Hood, the Director of our Community Prosecution and Violent Crime Division. Good afternoon, and please take it away, Bob.
Good afternoon, and welcome to another APA Final Fridays webinar. I am Bob Hood. I'm Director of the Community Prosecution and Violent Crime Division here at APA. And I'm joined this afternoon by two esteemed colleagues, the first being Michelle Waymeyer, who is Chief of the Community Prosecution Division of the Marion County Prosecutor's Office. Michelle has been in that position in Indianapolis since 2002. She started with the Marion County Prosecutor's Office in 1995. Michelle has attended and served as faculty at numerous community prosecution workshops during her years as a community prosecutor, and she has regularly served as a faculty member presenting ethics training at such conferences. Good afternoon, Michelle, and welcome. John Elison is the Mesa City prosecutor. He was appointed to head the Mesa City Prosecutor's Office in January of 2012. For those of you who are not familiar with the facts, Mesa is the third largest city in Arizona and the 38th largest in the United States. The Mesa City Prosecutor's Office handles about 22,000 criminal cases a year. John is a career prosecutor and previously spent over 11 years with the Maricopa County Attorney's Office. John is a frequent lecturer at schools, police departments, and legal conferences, and has taught for the Arizona Prosecuting Attorneys Advisory Council and at the National District Attorneys Association. John will be part of APA's faculty group for the 8th National Community Prosecution Summit, which will be held in Philadelphia in September this year. And good afternoon, John. Michelle Waymeyer is going to take us through an initial review of Brady material. Michelle, why don't you begin that process?
Looks like we're having some slight difficulties. If you could please hold on for 1 second, we'll get that resolved and continue the webinar presentation. Thank you.
Are we ready, Bob?
We're all set, Michelle.
Okay.
Yeah, we apologize for the technical difficulties. We seem to be having some problems with the platform, but I think everything is in order. So, Michelle, could you take us through the review of Brady, please?
I sure will. For those of you who weren't able to join us the last time, as you can see on the screen, there have been 8 cases since Brady that have refined our role and responsibility as prosecutors. And those starting with the Giglio case and ending with Connick in 2011. Bob, can you hear me?
Yeah.
Okay. Let's move on to the next. Why is Brady important? Our obligations as prosecutors to be ministers of justice, they were spelled out a long time before the Brady decision. As early as a case out of Pennsylvania in 1845, Rush versus Kavanaugh, the court stated that the prosecutor is expressly bound by his official oath to behave himself in his office of attorney with all due fidelity to the court as well as the client, and he violates it when he consciously presses for an unjust judgment, much more so when he presses for conviction of an innocent man. Then in 1908, Canon 5 of the ABA Canons of Professional Ethics were written, and they also stated that the primary duty of a lawyer engaged in public prosecution is not to convict, but to see that justice is done. The suppression of facts or the secreting of witnesses capable of establishing the innocence of the accused is highly reprehensible. Since the Brady decision, the U.S. Supreme Court, as well as lower courts, have issued a number of decisions concerning the scope of our disclosure obligations under the Due Process Clause and have established a constitutional minimum standard. However, those decisions certainly don't preclude jurisdictions from implementing more stringent obligations via statute, rules of procedure, or rules of professional conduct. The implications for Brady, for violations of Brady and the ethics rules are varied and vast and encompass what I refer to as the big Ds. And there are 4 big Ds that we should avoid. The first one I call do-overs, which are the protracted appellate litigation, conviction reversals, and new trials. Second one are disciplinary complaints. Third are damages, Section 1983 lawsuits, civil and monetary damages, and the fourth and final would be disbarment. In the Brady decision, Justice Douglas wrote that, quote, the suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or punishment, irrespective of the good faith or bad faith of the prosecution. 36 years later, after Brady, the court in Strickler versus Green did a review of the progression of the case law that follows Brady and spelled out 3 elements of a true Brady violation. First, they talked about the Aggers case, in that the duty to disclose such evidence is applicable even though there has been no request by the accused. In the Bagley holding, the court stated that the duty encompasses impeachment evidence as well as exculpatory evidence, and evidence is material, quote, if there is a reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different. In the Kiles versus Whitley case, which has probably had the most significant impact on law enforcement agencies and has shaped and will continue to shape office policies with respect to Brady lists, the court stated that the rule encompasses evidence known to police, and the individual prosecutor has a duty to learn of any favorable evidence known to others acting on the government's behalf. The Strickler court also pointed out that although the term Brady violation is sometimes loosely thrown about, there are three components of a true Brady violation. And those three are, number one, the evidence at issue must be favorable to the accused, either because it's exculpatory or impeaching. Number two, the evidence must have been suppressed by the state, either willfully or inadvertently. And number three, prejudice must have occurred. Turning to 2009, the court in the Cohn versus Bell decision, when you read this case, you should pay particular attention to the footnote 15 of that majority opinion, because the court actually cites the ABA Model Rule 3.8D, which actually sets a higher standard of ethics than the constitutionally required standards from the case law. And I'm reading from footnote 15. It says, although the Due Process Clause of the 14th Amendment, as interpreted by Brady, only mandates disclosure of material evidence, the obligation to disclose evidence favorable to the defense may arise more broadly under a prosecutor's ethical or statutory obligations. The court went on in that footnote to say, as we have often observed, the prudent prosecutor will err on the side of transparency, resolving doubtful questions in favor of disclosure. Also in Cohn, the majority opinion of the court left unresolved the extent to which the courts can grant relief for a prosecutor's failure to abide by this higher ethics-based but not constitutionally mandated standard. The most recent opinion was Connick versus Thompson in 2011, and a divided court in that case, a 5-4 decision, held that a prosecutor's office could not be held liable for the illegal conduct of one of its prosecutors when there had only been one violation resulting from that deficient training. And I think there's a note of caution to be had with the Connick case. I think this certainly doesn't mean that our offices get any free pass on training, nor can we be lax in our duties of training. There are some pretty scathing dissents in this case, and I think we need to take extra steps to train our prosecutors on Brady and its implications, or I predict that the next case that's handed down from the Supreme Court is going to have a vastly different outcome. I'm going to finally touch on the ABA Model Rule of Professional Responsibility 3.8, which is up on your screen now. And as you can see, Section D is the specific section focusing on discovery and disclosure requirements. It spells out a higher standard for prosecutors than the constitutional case law, requiring discovery of information or evidence that is favorable to the defense without regard to the anticipated impact of the evidence on the outcome of the case. I think supervisory lawyers in all our prosecutors' offices are obligated to ensure that all lawyers comply with legal and ethical obligations, including in the area of disclosure and discovery. Office protocols and procedures must be implemented, and ongoing and adequate training on ethical obligations are a must. This is particularly important when multiple prosecutors work on different aspects of a case and then pass the case along to another prosecutor like we do here in our office. I'm going to turn it over now to Bob and to John so they can drill down on these Brady protocols and Brady lists.
Thank you for that review, Michelle. I should mention, for those of you who missed our Brady webinar, Part 1, that entire webinar is available at APA's website, and you will be able to access that as a result of your participation in today's session. So before I turn it over next to John, let me just review briefly what are Brady protocols and what are Brady lists. I'll start with Brady lists first. Brady lists consist of listing occurs when a prosecutor places a law enforcement officer's name on a list disclosing what the prosecutor deems to be material and exculpatory material concerning that officer's prior conduct. Brady protocols, on the other hand, are established protocols, and they set procedures for disseminating Brady material, for notifying officers involved in any Brady disclosure, and for responding to third-party requests for Brady material by the media, defense attorneys, private investigators, and in Freedom of Information style requests. Our next presenter, who I introduced earlier, John Elison, actually was the moving agent behind getting APA very interested in this particular topic. He actually came to us as a result of a technical assistance request that came from John. I'm going to turn it over to John to let him describe how he became interested in this issue and some of the issues he faced as he drilled down into that. John?
Thank you, Bob. Yeah, first I want to shout out to anybody from Arizona. But I became the city prosecutor here in Mesa in January of 2012, and one of the first things I wanted to do is make a more formal Brady protocol and a Brady list. And so in doing that, in where we are in Arizona and where many of you are listening may be, there are many different jurisdictions. You could have multiple police departments. We live in Maricopa County, and we have a county attorney's office, and I'm in one of several of the different city prosecutors' offices. So really you look at the different parties that are involved. You know, if you're setting up a list, and when we were working on setting up a formal list and formal process, then you have to look at all the different parties involved and the processes there. And obviously one of the first parties that's going to be involved, and as Bob said before, we really did any of this, I did call Bob and Steve at the APA and get some technical assistance and some ideas. I also spoke with people in the City of Phoenix Prosecutor's Office and the Maricopa County Attorney's offices on the ways that they handle these kinds of things. But first of all, with the police, I want to talk about that. You may have in your jurisdictions, and in mine, there's several different police departments. We have one primary department, the Mesa Police Department. And it's important that that I establish a good relationship with the police department. And so, I met with them and we talked about wanting to do this, and, they were 100% on board with doing this. And I'm going to talk about kind of how you do that. Most police departments, if not all, have some kind of internal affairs department. And in the internal affairs, it might be several officers, it could be one, but I try to help them any kind of guidance, case law, and let them know kind of what kind of things we're looking for in Brady material. And we started off with just requesting that, hey, once there's an IA investigation and there's been a finding of some kind of misconduct, then that would be formally sent to the prosecutor's office. And that is happening now. And then with that report that we get from that formula list usually comes a summary of the internal affairs investigation, and sometimes there are underlying police reports. One of the things that we did when setting up this process with the police, we really want to make the police feel like this is a fair process because we want their buy-in and we want their support like we have. And so we told them, and we have a process into place so that if and when we're notified of something from our IA bureau, from our police department, the officer is notified, and he's given a certain amount of days to provide us, before we do our review here at the prosecutor's office, that officer is given time to present any kind of, I'll use the term mitigating, but you could say extenuating or any kind of facts that he wants to present, he or she wants to prevent with any kind of mitigating information as to the particular IA investigation that we're going to review. Then at our office, we sit down and we would talk and go through it. But before that, I'm going to go through that separately. But there's a discussion with, after our discussion here at the City Prosecutor's Office, we would have a discussion also with our Maricopa County Attorney's Office Ethics Committee, because our police department would send the same report to the county attorney's office as well. And we would have a discussion with them and make sure that we all see things the same way ethically about whether or not this officer should be listed. Then we decided that we would set up a process to formally notify the police department. So the officer would be given notice that he actually was listed or not listed, depending on what the decision is. And so again, one of the things that in order to get the buy-in with, we wanted to make the police feel like this was going to be a fair process. one of the things that I recommend, and one of the things that we did get from our police department, is this agreement was actually made into written policy for the police department. So this will continue to go no matter which supervisors happen to be in the internal affairs unit. I also recommend, and we have done this, but we meet regularly with the IA unit and the officers. And I forward them case law when new case law comes out about different Brady issues and things like that. And we've also reached out, in doing this, we reached out to our police union, and they knew about it and were supportive of it and liked the extenuating, as I was talking about earlier, with the officer being notified early and giving a chance to present any information. And then the other thing that we do, kind of now moving, I want to talk a little bit about kind of what we did internally at the prosecutor's office in establishing our Brady list and Brady protocols. We set up a committee. You know, it depends on the size, I think, of your prosecutor's office, but in our office, we have about 16 prosecutors. So we set up a committee with 3 people where it was myself, 2 of my senior supervising attorneys, and then I pull in at we meet separately every time there's an allegation to review or anything like that, and then I bring in one of our younger attorneys to kind of give them the experience of, hey, this is how this works. What we do is we provide them, obviously we set a time, and we meet in one of our conference rooms here, but we give them the materials that have been provided to us by the police. We emphasize, every time we do this and we sit down, I always emphasize with them how important it is that we are ethical and that we do everything above board, and also that, you know, this person that we're going to talk about is a police officer and, you know, he's got a career and things to think about. So everything that we talk about when we meet to go over one of these, I tell them this is really confidential at this point. We need to just really respect their privacy as well. And then we have a very in-depth discussion where we review again the materials that have been provided about this subject officer, which could include the IA report. Now, sometimes an IA report is a summary. Sometimes it's a detailed report, but sometimes there's also police reports that go with that. We also have reviewed in our Brady reviews, we've reviewed court documents, grand jury indictments, different things like that. But also another thing that you could review is any information provided from the subject officer of the review. And, you know, I try really hard, and I encourage this discussion to be very open and frank. And after going through it, we vote. And after voting, then sometimes there's decisions to be made. Okay, so we did this vote. We voted to disclose this. And, sometimes the decision could be, and I'll talk about this in a minute, concerning how we're going to disclose this information, whether it's going to be through the in-camera inspection of the court or directly to the defense attorney. But after our Brady review, we go ahead and we sit down and we collect the materials, and then usually I get on the phone, or I would get on the phone with county attorney's office and make sure that, and have a discussion with them after they've completed their independent review. And the way I see it is Rule 3.8 is an obligation on every prosecutor, but every prosecutor's office needs to make their own independent decisions on what is or what isn't Brady material. But after that, then we would contact the police department and the officer and let them formally know that what decision has been made, so that there's no question there. And then, as I was talking earlier, there's a decision on how this is going to be disclosed. One of the things that we, at this point, we just kind of let people know in our office, hey, if you see this officer, then you need to come see me or one of the supervisors about the potential Brady information. What we're going to be doing in about 30 days is we've purchased a new software system for our case management, the Prosecutor by Carpel, and in that system we will put in there, we'll have a secure system. We have a secure system that can really only be accessed by myself and my supervisors. But anytime, let's just say Officer Smith, who's now been on the Brady list, anytime he is a witness, then my attorneys will be automatically notified that, hey, this person, this is a Brady alert, you need to go see your supervisor. And we keep copies of that internal affairs information. And then at that point, if a prosecutor sees that, then they come in and we would have a discussion with them and tell them what the Brady committee's decision was. Such as, it could be, in this case, I'll give you one example that we had. It was pretty old. I want to say over 20 years old. And we decided that, okay, we need to disclose. We think we need to disclose this, but since it's so old, we're going to send this to the judge. So we filed a motion for an in-camera review, and we asked the judge to tell us what our obligations were under Brady v. Maryland and Ethical Rule 3.8. Sometimes, though, you could have something that you review in your Brady team or your Brady committee, and you can say, hey, we need to just disclose this, and we would just disclose that straight to the defense attorney. So kind of to summarize it again, this is really important when you're establishing a Brady list and Brady process is you identify all the potential parties that could be involved, the different police departments that you work with, and then work out a way in agreement with them so you can you get notified, and then you can notify people as you need to and as your ethical obligations require it. So I'm going to turn it back over to Bob to talk about drafting a Brady policy.
Great, and thank you, John. Obviously, undertaking the task of formalizing a Brady protocol and Brady list set of procedures is a significant job that, as you say, requires the cooperation of a lot of other entities within the criminal justice system. I'm going to now proceed to kind of walk you through the elements of drafting a Brady policy. And before I do so, I do want to remind you of what Tina mentioned a little bit earlier in this webinar. These examples that we are using here are for illustrative purposes only. The case law in every jurisdiction is different. In some cases, as we saw in the first webinar, even your ethical obligations may be different. And to be able to address all of you would be well beyond the scope of an hour-long webinar, given the sometimes dramatic differences between what the case law may say about turning over material, what your local jurisdiction's ethical obligations have been found to be. And then, of course, we have a whole body of state law, state case law that has a profound impact on Brady practice in an individual jurisdiction. So please, again, just take these as illustrative points. I think they're good things to keep in mind as you attempt to draft such policies for yourself.
Hey, Bob, if I could jump in real quick, one of the advantages, I think, of drafting and actually having a written policy is, if you look at the Connick opinion and some of those other ones, the fact that you have a written policy about this, I think, is good evidence to kind of protect yourself in your office.
Yeah, I think that's a very important point, and that actually is touched upon in that first bullet point that you're looking at is the key components of putting a policy together, which is a case law review, statute, and court rule review of what your jurisdiction's law is and what your office's interpretation of those things are. But the key components are, first, case law, statute, and court rule review is a common element in one of these policies. The notion of reinforcing that this is an individualized prosecutor responsibility. That is, every prosecutor is under an ethical obligation and as well as legal obligations in turning over evidence, and that cannot be forgotten. Another element that we see in a lot of these policies is the notion of centralized authority along the lines of what John described. There's either a single person in some cases or a committee or perhaps the prosecutor and the first assistant. There's centralization of the Brady policy process so that it's not disparate and all over the office. Another thing that you'll see frequently is a specific procedure for listing an officer. And again, thank you, John, for describing what you're doing in Mesa, because that's a good example of how a procedure can be described. And then there's the question of standard of review, and what level does the evidence have to come to in order for a prior act of the officer to become Brady material. And then John touched upon this notion of supervisor officer notification and defense attorney notification. We're going to take each of these things apart a little bit and talk about them a little bit further. Obviously, the policies frequently have a section, usually at the beginning of the policy, that describes the office's interpretation of what the applicable Brady case law is, both federal and state, any relevant statutes and court rules or disciplinary rules that bear on the obligation to provide discovery for Brady material. Part of the purpose for this is obviously every attorney in the office is going to have an interpretation of what they believe the Brady case law says. But if you're in an office of significant size, as John has described, 22,000 cases there in Marion County and Indianapolis, obviously a large urban prosecutor's office, but all offices that are of any size need to at least come to grips with the notion that Brady material and Brady material that is turned over is consistent, whether you're, regardless of which attorney you're appearing before in an office. So this review helps to establish that consistency and also train the office's attorneys on what all of those things are. As I said, another notion that we see in a lot of these policies is this notion of individualized prosecutor responsibility. At the end of this particular PowerPoint presentation, there's two links, one to the Los Angeles County District Attorney's Office and a second link to another office in California that has promulgated such a policy. Those things are online and publicly available, so you can actually take a look at those. And we've used those, again, just for illustrative purposes in the context of this webinar. The LA policies have been around for a significant period of time, starting in 2002 when they were first posted onto the World Wide Web. They've gone through some changes as different district attorneys fill that particular seat in Los Angeles County. But I think it's a great tool for other prosecutors around the country who are interested in building their own policies. And I should note, we've kind of picked and chosen examples throughout, so what we're talking about may not be the exact version of what Los Angeles' policy is at the moment, and I apologize for that. But again, we're doing this just for illustrative purposes and to help prosecutors develop their own policies. As I said, it's an individualized process. Every district attorney has the obligation to comply with the mandates of the Brady case. And this particular language you'll see in quotes is out of the Los Angeles District Attorney's Office policy. They have what they call a Brady alert system, which John made reference to. Some of you, if you have records management systems that are capable of putting flags into the system, either behind defendants or witnesses, you can create, in essence, a Brady flag, which would notify you every time that that person is entered into a case as a witness. A flag would come up and, in essence, warn the attorneys handling the case that there is a potential Brady information that has to be taken a look at. In the LA County example, they also make a reference to the fact that the individual trial deputy has the final decision as to whether or not to call a witness who has Brady material that would have to be turned over after a consultation process with the head deputy or deputy in charge of the Brady unit. So keep those things in mind if you're trying to build policy of your own. Another feature I mentioned a little bit earlier is this idea of centralized authority in the LA DA office example. There's an actual unit within that office, a Brady compliance unit, which decides whether to include information about an officer or governmentally employed expert witness into the system. And such a decision is usually made after an investigation's been completed and some determination's been made. However, in some cases, sufficient evidence actually may justify inclusion of information of that sort in the Brady system, and we'll talk about that a bit later in the Q&A portion of the webinar. Where you centralize this process varies significantly, or can vary. You can leave it to the chief prosecutorial officer of an office. It can be a committee. It can be a supervisory attorney. I've seen many different kinds of examples of where this authority can be placed. Let's talk a little bit about the procedure for listing an officer. And again, going back to the LA context, if the compliance unit determines there's a clear and convincing evidence that potentially exculpatory impeachment information exists, they're the ones who are responsible for entering the Brady alert system information in and to inform the supervisory staff of that office that has occurred with respect to that defendant. Talk a little bit about the standard of review of an incident. When you think about Brady information, I think it falls along a continuum, or what you could consider as Brady information. There's some information that's quite obvious that probably no prosecutor you would talk to would disagree that there was an obligation to turn over. On the other extreme, you have speculative information, information that hasn't been verified, even maybe even hearsay at this point, or that can't be resolved. And it's pretty clear, reviewing the at least federal case law, that information that is unverifiable and is nothing more than rumor and so forth is not Brady material, and there's no obligation to provide that. But of course, like all things legal, there's stuff that falls into the gray area, where you're essentially drawing lines between when there's a duty to disclose and when there isn't. And probably the best guide we have is from the cases that Michelle earlier provided to us. The Supreme Court, in talking about Brady, is when in doubt, release. You very rarely are going to get into ethical trouble for releasing information. The risk comes when you make a decision to not turn over information that eventually may lead to a reversal of a conviction or ethics problems for you and your office. The LA County District Attorney's Office at one point was following what they described as a clear and convincing evidence standard. Ventura County specifically rejected that standard and uses a substantial information standard in citing when Brady material has been established to the point that it needs to be turned over. So just be aware that there is some difference of opinion out in the prosecutorial world about what the standard should be. And thus far, the courts have not resolved that question or even addressed that question, at least at the national level. But again, take a look at your local state's case law to see where you're at.
Bob, if I can jump in just for a second.
Yeah, certainly.
There is case law out of California that the prosecutor has immunity for placing an officer on a Brady list. So I think, sometimes offices may be a little alarmed, am I going to get sued for placing someone on a Brady list? And there's at least case law out of California that states that the practice of putting the officer on a Brady list is an act undertaken by a prosecutor in preparing for the initiation of a judicial proceeding and trial, which is entitled to protection of absolute immunity.
Yeah, thanks for raising that point. Michelle is our resident expert at APA on the immunity issue, and obviously there's an interesting interlink between prosecutorial ethics in general and the whole specifics of the conversation concerning prosecutorial immunity, and now overlaid this whole area is this notion of Brady lists and Brady obligations. It certainly has made practicing as a prosecutor a much more complex world. I started practicing as a prosecutor back in 1982, and I can assure you these developments are ongoing, and the only way we can make sure that we're complying with them is to stay abreast of what is happening. So there's another notion that you see in a lot of these, and again, we're taking another quote out of the LADA office's policy. The Brady Compliance Unit has some obligations to inform the head of the employee's agency in writing the placement of the employee's name and information into the system, and of the attendant discovery consequences that flow from that. John also mentioned in the MESA context this notion of notifying, in his example, the actual officer involved. If you look at the history of some of the developments of Brady protocols in California and in Los Angeles in particular, this was a fairly sensitive issue for officers and officers' unions in California. But it's something, I think, as John has pointed out, by working with the police, including police officers represented by unions, you can reach good policies that everybody can be comfortable with. Another element, obviously, is somehow at the end of this process, you have to decide how you're going to go about alerting the defense about the information, and it kind of falls into two categories. And the first is for existing cases where the attorneys are in an ongoing relationship in terms of prosecution. Again, taking from the Los Angeles policy, deputy district attorneys have an obligation to access the Brady alert system at least 30 days before going to trial to determine whether any kind of information of that sort exists with respect to an officer or a governmentally employed expert witness. You'll see that in some of these policies. In this particular example, 30 days triggers because of some obligations under California statutory law. So you'll want to be aware of those timing triggers and build them into the policies that you operate under. That policy also talks about how a deputy appearing in a court on a case has the responsibility of actually notifying the defense directly of the information, documenting what the information was that was disclosed in the manner by which it was done, whether it was in writing or on the record. The LA policy went out of its way to note that the defense only got information on cases that were being litigated before the court on them. So this was not a general release to all the attorneys in Los Angeles. It was specific to the case and specific to the attorney. Inevitably, you run into the situation where you have prior cases where a witness has appeared, and subsequent to their appearance in that case, these policies try to get into this question of how far do you look back and who do you look back to in terms of notifying potentially exculpatory information. In the LADA context, office context, because obligations under Brady continue after a case is concluded, they cite the California authority, then the Brady unit, if there's potentially exculpatory impeachment information that exists, they'll reach out to those attorneys and notify them that there is now Brady material with respect to a case, even if a case is closed. There's another section of that policy, if you review the full policy on their website, that does point out, however, that because of the federal case law, in situations where defendants plead guilty to offenses, that there's no obligation to go back and provide information in which the cases concern police. So we'll have to see where that principle continues to lie in the federal case law, but it dramatically reduces the number of times that you actually have to reach out to attorneys because, as we all know, most cases resolve in police. Before I move on, Michelle and John, anything you'd like to add in terms of, what the state of affairs was when you began to look at this, and how these various components might fit in terms of a Brady policy?
Michelle?
Yep. Go ahead, John.
Well, Bob, one of the things that we talked about, and one of the hard things in the earlier slides, is once you get notified of something, then and then you take the time to do the review, what do you do about future cases and past cases? I think that's something that maybe we can talk about when you finish. But I mean, that's been one of the things that we wrestle with when we get something like this.
Yep. And Michelle, just out of curiosity, what was your situation in the Marion County example in terms of the Brady process?
We actually have a case right now where an officer is under investigation, and the investigation isn't complete. And so what we have done is reached out to all the court supervisors, trying to find out, does this officer have any pending cases? Because we're not ready to pull the trigger yet because the investigation is not complete on notifying them, but we feel it's important to figure out how many cases he has, and if we have to try to delay those cases until we've got some sort of resolution on whether this is in fact going to be a Brady issue or not.
Okay. I think, given our time, we'll move on to just a couple other issues that seem to steadily arise when offices go down this path. The first is, or the first question that the office needs to resolve is, are you going to disclose the policy? A number of offices do so. As I said, you can actually find examples of that from Ventura County and from LA and from Santa Barbara County in California. There's some other locations as well. There are others that consider it an internal document. We should add, when you try to grapple with this issue of public disclosure of the policy, your local state's public disclosure laws sometimes will actually have exceptions that would permit you to not actually have to release the policy per se. In the section that describes your office's legal theories and point of view in terms of the case law and what you're training your attorneys to do, there's very good arguments that a lot of that is work product, especially if you're talking about legal theories and how you view the case law affecting your obligation to release. So there may be situations where, because of the local disclosure rules or matters of work product, you can, if you choose to, not release the policy for public consumption. Other offices take a look at that, and even if they could not release it, if they choose to do so in the name of transparency. Some would argue that this is a good thing for prosecutors' offices and for the police, because it helps to improve the transparency of the operations of their offices and instill confidence by the public in what their offices is doing. I'm not going to tell you which is the appropriate view, because I think that's something for every office to decide for itself, but just be aware there is that issue of do you have to disclose the policy, and even if you don't, do you want to? Second issue we see is the question of the public disclosure of the lists themselves. And I'm not talking about the full files that are tended to an officer's individual Brady cases, but these would be lists of the names of officers who are at least have some material that is being recorded with respect to them in relation to releasing Brady information. Again, you're going to have to look at your local public disclosure laws and see if what is or isn't protected from disclosure. That in some cases will dictate whether the actual list of the officers involved is available to the public or not. And that would include the context where there's been a public disclosure request by the media or the public under those laws. The other issue that you should be take some concern with is what your local state law may be in terms of privacy rights of officers. In the California context, there actually is statutory authority which does affect the ability for offices to turn over specific information. So if you have statutes, you obviously want to be careful to concern yourself with that. And then in another area, we have this whole issue around judicial in-camera review. In the state of California context, you have case law that actually directs judicial in-camera review in instances involving police officer employment records. John has described a process where you can actually seek out judicial in-camera review in order to
talk about that for a minute, Bob.
Pardon me?
So let me talk about that for just 1 second. So a judicial in-camera review is where you actually send maybe the IA file or police report, whatever information to the judge, basically saying, tell us what our obligation is under Brady v. Maryland and its progeny. And with that, you know, as it says on the slide there, you would want to do some kind of protective order. And the protective order could or should say something like, you know, Mr. or Mrs. Defense Attorney, upon completion of this case, you have to return this to the prosecutor's office, and instruct them not to disseminate this or to share this with other people. You know, in the different city courts and the county courts I've worked in, judges really don't like prosecutors asking them to do this. They just don't. And I've had conversations with several, and I think they feel like, you know, hey, if you think you need to disclose it, disclose it. Don't involve us. Do you have any experience there, Bob?
Probably just the practice pointer is I think some judges will actually give you an in-camera hearing and do that. And as I said, in the California instance, in terms of police officer employment records that touch on Brady, there's actually a process built in the statute for that. You know, ultimately, if if it is a gray zone case, I think it offers the prosecutors involved a certain amount of protection. If, for instance, they are subjected to disciplinary action or attempted disciplinary action after the fact, I think the fact that the prosecutor's office or the prosecutor involved attempted to get judicial intervention help them with that decision, it casts the case in a far different light if you just make that decision yourself and just go full bore from that point. So, and even if you sought out judicial review in an in-camera process and the court rejected doing that, at least you've done everything that you can do. The other avenue that we should suggest is that most state ethics entities within the state bars will also entertain inquiries on ethical obligations. So again, it's a far different disciplinary action if the prosecutor can say, well, I tried to get some assistance from the court, and I tried to get some assistance from the state bar. Ultimately, I had to make the decision, but at least I did everything I could to try to do the right thing. So I don't think you ever get hurt from that aspect in trying to get that assistance, in particularly those gray zone cases. John or Michelle, do you have any other feeling on that particular topic?
No,
I agree, and I think actually if you can tell the judge if you're doing an argument or something like that you've also sought the advice of the bar, that in practice that's very helpful.
Okay, and then let's move to protective orders and admissibility, and goes directly from the point that John has described. The fact that something is Brady doesn't end whether it's actually admissible in a trial. So you should be aware of that and also build that into your policies to make sure that the attorneys do get appropriate protective orders and do fight admissibility questions when they're appropriate, even for material that's been turned over to the defense. And then finally, we should mention this notion of automated alerts and databases. There's got to be a way that you can consistently keep track of this kind of data. And if you have a data management system that lets you create some kind of alert and pull up all the cases that you need to when you have an involved officer, you're obviously going to be in a better situation than if you have to hand check files and go to paper lists and that sort of thing. Unfortunately, that's beyond the capacity of some officers because of the state of their systems, but certainly you should think about that, both in terms of when you're planning on buying a system and in terms of how you can use those systems to further your Brady activity. Unfortunately, we're getting real short on time. Are there any other questions? I know John and Michelle, you've been kind of keeping an eye on the question count. Can you identify any questions that you might want to take on?
John, do you see there's a specific question on your detail process?
Yes.
Yeah, I think the question goes,
let me go to this question. Let me read it. Can the Maricopa, the Mesa City prosecutor, please describe a bit more detail the process by which law enforcement officers are advised to provide any extenuating circumstances relating to his or her underlying Brady issue? Is this an opportunity given to each officer as a matter of right to just appear before the Brady committee? If so, is she represented by union counsel? Now, I'll be frank about this. We've set this process, that certain part of the process up. We've never had an officer do that yet. But no, it is just in the agreement. It's not a right necessarily, but it's an agreement that we have. It's written in the police department's policy, but it's written. It's something in writing. So we wouldn't be meeting with the police officer or their union representative or counsel. I think though that the police really appreciate that, and that makes it so we're more likely to get the information that we need.
Just kind of scanning the questions, it looks like we've covered most of them. And Michelle, I see someone was interested in the immunity case out of California, which you have provided to us. If you've submitted a question that hasn't been answered, APA staff will, we actually can record those questions in our webinar system, and we'll certainly get back and answer any of the questions that we have. John and Michelle, any last thoughts before we sign off? We're just about out of time.
No, I was just going to say the Internet's, if you explore the Internet, it's full of some interesting Brady lists and Brady policies out of Florida and California and some of the other states. So if you're starting to put together something, you might look for guidance from some other jurisdictions.
And John?
No, thank you. And if anyone has any questions, further questions, contact APA, and we'd be happy to answer them.
And we'll be
yes, and
all in Philly too, so come to the conference.
I should add the 8th National Community Prosecution Summit in Philadelphia will include an entire breakout session, including John and Michelle and others on this very topic, and we'll go into some more detail on how to construct these particular lists. I want to take this opportunity to thank you. If you're interested in registering for that conference, you can do so at apa.org. I certainly want to take this occasion to, on behalf of APA and our listening audience, to thank John and Michelle. And with that, I think we're concluded for today, and we'll return it to Ema.
Thank you, Michelle, John, and Bob, for the excellent presentation. The webinar materials and recordings will be available at no cost on our website, and we will notify you via email when these materials become available and how you can access them through a temporary membership. If you are a current APA, prosecutor, court, law enforcement, or criminal justice partner member, you will have automatic access to the webinar materials once they are available online. If you have any questions or concerns, please send them to us via email at webinars@apainc.org. And don't forget to fill out the survey that we will be sending out in a few minutes. Thank you so much for attending. Have a great weekend.